Good afternoon, and welcome to HIPAA and Business Associates, Tales from the Trenches. Thank you for joining us today. I'm Angie Singer, and I will be your facilitator for today's session. We're very excited to bring you this webinar. This is the third and the final webinar in a series brought to you by Reclamere and Rhoads and Sinon. As always, I'll start with just some housekeeping items. Today's presentations, as the others, will be presented in a conversational format, but we will open up for additional questions at the end of the session. So please feel free to send over questions using the question feature on your GoToWebinar panel. Also, we'll follow up with all registrants and attendees to answer any questions that we might not have time to address, and we will provide additional information and, of course, next steps at the end of the webinar. I do want to let you know that the webinar is being recorded, and we will provide the link to you in our follow-up so that you can share the information with other members of your team. If you missed the last two webinars, we highly recommend that you request those links as well so that you can utilize them in your organization. I'm very pleased once again to present your expert speakers today, Angie Singer Keating and Renee Martin. I won't be spending a lot of time on their bios since we anticipate that you know them by now, but as expert speakers on this topic, actually combined, they bring over 35 years of professional experience in everything from data destruction, data security, and all the related topics. So for those of you who joined us for the first two webinars in the series, you also know that Reclamere is a data security company offering a full range of specialized IT asset management and information security services. And Reclamere also offers several educational opportunities throughout the year. I also always like to note that Angie and Renee work closely together to provide exceptional and affordable full-service consultative and legal work, and certainly in regards to today's topic. I really think you're going to have a sense for their complementary work as we move forward with today's presentation. So I'm going to go ahead and get started. As you can see on the screen, the agenda for today. I will take a minute to review the last two webinars so that you have an idea of the information that we covered in the past if you would like to request it. But for today, we're going to break the webinar into two sections. Angie Singer Keating will really handle the first section, which is going to talk about forensic case studies. And as you can see, it's going to cover everything from incident review, incident overview, to breach determination. At that point, Renee will be leading the discussions during the second half of the webinar, really getting into some legal case studies, picking up at breach analysis, and walking us through everything to regulatory involvement and PR and legal ramifications. So I really feel that you're going to find the information useful but also interesting as they're going to talk about some of their real-life experiences, as we said, in the trenches. For those of you who joined us in the past, you may recall that we discussed business associates and subcontractors as it pertained to HIPAA, really with some focuses. In webinar one, we started with some of the basics, what you really needed to know. So it was kind of focusing on the impact to business associates and their relationship with covered entities. Everything from how it's regulated to mandated provisions, scope of liability, and certainly enforcement. In webinar two, we got into the ins and the outs of vendor due diligence, really spoke more about the business associates agreement, how you negotiate the correct agreement, and who is responsible for what. So again, very good base information to what we're talking about today. This session is really going to give you, as I said, an opportunity to delve into how these areas actually unfold in real-life situations. It's certainly one thing to read about what you need to do, but quite another to truly understand how a breach may play out in real life. it also makes it that much more memorable. So without further ado, I'm going to go ahead and turn it over to Angie Singer Keating to introduce the idea of preservation of evidence. Angie?
Thank you so much, Angie. I really am happy to be doing this third installment. Kind of sad it's the final one. I've enjoyed definitely learning from Renee also. I always get a chance whenever she and I work together to learn from her, but I especially enjoy hearing her on our webinars. So where I wanted to, I'm sorry, go ahead, Renee.
I just want to say thank you. The feeling's the same.
Thank you so much. So what I wanted to start with is we're doing the Tales from the Trenches just a little bit differently, whereas normally we would focus on the actual matter or incident. We're going to take you through the various aspects of taking an incident from all the way from the discovery all the way through potential ramifications post-breach. And doing that, we're going to talk about different incidences. One of the very first areas, whenever we're called to take a look at a security incident, and it's very important to use that distinctive term. We don't ever use the word breach until we are much, much further down the road, because in the beginning, we rarely know if it is truly a breach. We also don't know if it rises to the legal definition of a breach. And so at the outset, when we have an incident, and that incident clearly gets escalated to the point where there is the potential, that is where preservation of evidence is absolutely crucial. And evidence is not just the forensic images that are collected. Evidence in many cases is also the documentation, the email trail, the way that the help desk ticketing has flowed through an organization. It's very important that all of that information is preserved as the incident is being analyzed. And for that reason, that's one of the reasons why I always teach from a security perspective that any security incident, no matter how minor it looks, from potentially innocuous adware on a machine, that should be assumed that there may be the potential for further harm as the investigation goes on. Most of the time at these points, everything is being handled from a purely technical perspective. And the technical folks are really kind of focused on fixing the problem. And so it's very important that there is leadership and that the IT staff are educated to understand that while it is absolutely crucial to go through and take a look at what's happening from a technical perspective and deal with that, it's equally important that they understand that there should be documentation happening along with that. One of the matters that we've worked on where there was an excellent preservation, these tend to be organizations where, for instance, we had a client in healthcare where their website was defaced by one of the hacktivist groups out there, and the website was hacked, and the issue really was that the website was hosted internally on the same network as where the patient health records system also resided. And so immediately this client with their internal folks took the precaution of making images of the affected systems, as well as preserving logs coming out of the various network infrastructure appliances, such as firewalls and different routers and that type of thing. That's an excellent scenario when we get called. Unfortunately, many times what happens is that incidents have happened in the past. For instance, I have another matter that we're working on right now where 2 years ago, an IT staff member was notified that there was a drive on the network that was shared improperly and that everyone on the network could actually see it. And at that point in time, that IT person was not educated and was not aware enough to know that the fact that that folder had been, that drive had been out there and had been shared was in and of itself a potential breach. And it has turned out now 2 years later that we find that it is an actual breach, both of EPHI as well as state-regulated personally identifiable information such as credit card numbers and social security numbers. We're having an incredibly difficult time being able to figure out which records were accessed and what happened to that information over the course of 2 years. So education is really the key around preservation and helping the staff understand when they should escalate something that seems like an innocuous incident to further investigation at that time. So that kind of leads us right into the investigation on our next slide. And again, what I want to focus on here is the fact that the vast majority of the time in these types of incidents, the investigation is focused on the technical aspects, getting systems back up, finding out what types of malware may have infiltrated the organization, trying to ascertain what those types of malware were trying to do within the organization. And the challenge with that is that it doesn't take into consideration what actually allowed the technical failure to happen. And so that starts to go into areas of compliance and governance and risk management that too often get overlooked while the technical folks are doing all of their great work to get systems back up and running. So in this case, when I kind of compare and contrast different projects that we've done, different engagements that we've done for folks, when I look at a very well done investigation, what I generally see, if we can go back to the situation of the website defacement in a healthcare organization, in that case, as they were investigating, not only were the IT people involved, but the compliance folks were involved as well. And so throughout the help desk ticketing, there was good documentation of the investigation by the technical staff, but then there was also communication, again through the help desk ticketing system, where the compliance folks were engaged as well to help guide the investigation. The other thing that's absolutely crucial is that good legal counsel is involved at this point. In our company, we deal with many small regional hospitals and healthcare organizations. And in those cases, they don't always have in-house legal counsel. They have outside counsel. And one of the things that is most important to understand about an investigation is that it's absolutely crucial that your legal team, your legal representation have a good understanding and working knowledge of what happens in breach investigation. So just like many other professions have areas of specialty, areas of particular experience, the world of breach investigation, security incident investigation really does require some specialized experience in having worked in that way. And that's one of the reasons that I so appreciate working with Renee. Renee and I will work in a way where I will have a client that I'm working with, and clearly an incident that a client has contacted us about needs to be escalated, and they don't have legal counsel that has the specialized kind of skill set in having worked in these types of incidents. And so I will make referrals to Renee. Renee will likewise have clients where they've had an incident and she's realizing that there's a complexity and maybe a third party would be helpful to help out with the investigation. So when the two of us can work very collaboratively, we can really cover all of the bases and help each other very, very well. Unfortunately, in the investigation, when legal counsel is not involved or when outside security expertise is not obtained, there can be mistakes made that further down the road, if it is determined there is an actual reportable breach, mistakes may have been made that could be catastrophic in terms of whether it's public relations or issues around regulators. So as we work through the investigation, what we're really trying to get to is the root cause analysis. And on the next slide, when we look at root cause, we've really kind of simplified this because there are many, many root causes of a data breach, but fundamentally they will come down to these basic kind of categories. And oftentimes all three of them can be involved. You can have a system glitch that's exacerbated by human error, which then allows a malicious or criminal attack to happen. So when we look at root cause analysis, though, it's really, really crucial that we don't look past that we don't forget that there's more involved than just the technical root cause. So, for instance, when I talk about the healthcare organization that had a website defacement, the technical root cause analysis was a SQL injection. Now, for non-technical folks, what that means is that the back-end database of a particular website had a vulnerability that allowed a specific type of attack called a SQL injection, where code is injected through the website in a manner that allows access. Now, that was the technical root cause of how they got to the website. But how they got into the system to begin with, there was a further technical root cause, which was an unpatched computer in the marketing department. Now, that is another technical root cause because the unpatched system in the marketing department also allowed that marketing person to install her own programs. And one of those programs that she installed was a content management system called Joomla. And because she had installed it and the IT folks were not aware of it, it never got patched and it had a vulnerability. And so that vulnerability allowed the bad guys to basically come into the system, and then SQL injection from that point allowed them to then move from simply the website itself into the back-end database. But we're still not at the true root cause of this incident. The true root cause of how both of these things could happen go back to proper risk management with proper change control that involved proper patch management of all systems, servers that hosted the website and end users whose machines were allowed to download software that the organization wasn't even aware of. That speaks to policy, that speaks to procedure, and those were things that during a risk assessment may very well have been discovered. Because if there had been a patch management plan that was written and an auditor were to take a look at that and would say, prove to me that you regularly patch your systems, prove to me that you know all of the software that resides on all of your systems, that you have a proper software inventory. These are things that may have been able to have been detected and they may have been able to have been prevented. So when we just stop at, well, we had an unpatched system, or we stop at, well, we had a SQL injection, we're really not getting at the heart of the root cause. And that really, really fundamental root cause around risk management is so very, very important because that leads us into our business impact analysis. It is really, really challenging when we do our root cause analysis and then subsequently look at business impact analysis, it's very hard to prevent things from happening again in the future if we don't fully understand the root cause and how something happened. So if we move into the next slide and we talk about business impact analysis, here are areas where, let's say that we find that one of the root cause analysis findings happens to be human error. Depending on how egregious the human error, that could cause definite PR challenges for us. And so as we work through the root cause analysis, this is another area where we really want to have strong legal counsel. Renee, could you speak a little bit about how during this process of investigation, root cause analysis, and business impact analysis, why it's really important for you as legal to have some input and have knowledge of what's going on?
Sure. I just want to re-emphasize what you had said earlier about the need to get counsel involved, knowledgeable counsel involved at the get-go. When you think, as a security analyst, that there is, in fact, an incident which looks like it might be leading to a breach. Many of your clients that you're referring to could be in rural counties or in counties, or maybe they're smaller hospitals that don't have in-house counsel, and they rely on corporate counsel. And corporate counsel are great at doing transactions and, doing contracts, et cetera. But if they're not versed in what the HIPAA requirements are, specifically as we'll talk about later with notification, you could find that you're not really documenting or paying attention to what the root causes are, and then you'll have a very hard time providing information to the affected individuals and providing cohesive information to HHS or the OCR should they come in knocking at your door to find out more about what transpired. And the other reason why it's important to have legal involved is I have always found that there's one thing called a mistake, and obviously if it's something that can be remediated by further additional training and education of personnel, then that's one thing that you would want to do. You want to demonstrate that you've done it, and when we get to the notification process to individuals, you'd want to be able to include that in your explanation to individuals who've been affected. By contrast, if you know that you have someone who has acted recklessly or outside of the expected behaviors of the employee in terms of policies and procedures that they've been educated on as far as HIPAA, then you need to demonstrate, and one of the important things to demonstrate to outsiders is that this is a rogue employee that has not adhered to the facility or the provider's policies and procedures, and one way that you have dealt with this is that you've terminated that individual, and that's a very important step to take to show that you not only know what the root cause was, and maybe it is human error or maybe it is human behavior that was intentional, that you have severed that individual from your organization.
Yeah, thank you so much for clarifying that from the legal perspective. I think the other thing too is that, it's not just the technical folks who are responsible, and unfortunately too many times they get the brunt of the blame when something goes wrong. I can tell you that the vast majority of the time when we go into an organization to do an investigation of a suspected breach, what we find the vast majority of the time are incredibly competent and well-educated IT staff and IT security folks who for a very long time have been asking for the people, process, and technology to prevent the incident that they're currently investigating. And routinely, unfortunately, especially in healthcare, they're told we don't have money for that. And their requests are constantly denied.
That is absolutely true, and I have several clients that's the truth. They just, we know when they're doing their budgets and they have other important infrastructure or patient care needs, there are other regulatory things that are being imposed upon them. Sometimes the board of directors doesn't really understand the idea of informational governance or how important that is to the organization, and money is allocated elsewhere.
Yeah, and I think that's one of the saddest things. And I'm not going to mention the company, but it was a large big box retailer who had a very, very high profile breach not that long ago. And recently their former IT staff have been quoted in newspapers as saying, hey, we knew this was a problem. In fact, it was so bad, we told our friends and family never to use their credit card when they shop there. They should only use cash. So those are some of the potential PR issues, and Renee's going to get into those much more deeply later on. But sometimes when I have taught seminars or have written research papers and so forth, there's been this mistaken impression that I'm blaming the IT staff or IT security. And the true root cause is lack of risk management that identifies risks clearly, and that the IT staff has repeatedly communicated to upper management, who repeatedly deny those requests. So another thing that I think it's really important to point out here is, so far Renee and I have only been talking really about covered entities, and this series started out talking about business associates. Well, there's a really good reason for that. The business associate breaches are just now starting to happen. And so as a kind of proportion, at least in my organization, of the numerous calls we get every week, the vast majority of them are still covered entities. But I suspect and I predict, and I don't know what you would think, Renee, but I think if we were to do this same series a year from now, our Tales from the Trenches are going to include a significant amount of business associates who are going to have to be going through all of these things. Just
well,
a little
agree,
too
because
early.
With the HITECH Act now, business associates are directly liable, and there have been actually one or two cases that the OCR has prosecuted, and interestingly enough, they've been government agencies that have used other vendors, business associates. So you would think they would be the entities that would know better. But yeah, I agree that as business associates, as we move forward, you will see them being looked at and I guess not prosecuted, and that's, I think, the word to use, by the Office of Civil Rights.
Yeah, and I think that we can't even dream up all the potential scenarios, because when we look at business associates who are independent contractors, for example, there are transcription services where they have no direct employees. Every one of their transcriptionists is an independent contractor, which makes them a business attracted to the covered entity. How do you do a root cause analysis on one lady's home in Dubuque, Iowa, who does transcription from her living room? These are really complicated issues that we can't even at this moment truly foresee. So to wrap up my portion, the business impact analysis is so crucial, because the business impact analysis is going to document everything that's found in the investigation, all of the root causes that are found, technical as well as governance and compliance related. And then that information from your business impact analysis is what's going to be used to update your business continuity and disaster recovery plan. And people traditionally, unfortunately, think of disaster recovery planning as, well, we need to know what to do in case of an earthquake. We need to know what to do in case of a fire, a flood. But I can tell you that a denial of service attack or a ransomware attack where all your data is encrypted and you can't use any of it, and you can't treat patients, or you as a business associate can't do services for your client, that is probably, from a technical perspective, the equivalent of your systems physically crashing because of water damage. When you can't get to your data and you can't use it in today's world, that is a disaster. So that information from all of this work, investigation, root cause analysis, and business impact analysis, needs to be used for your disaster recovery and business continuity plan. And that is one of the best ways to demonstrate compliance with continual improvement, learning from your lessons, documenting that, and implementing the proper controls, policies, and procedures not to let something like that happen again. Now, a lot of people will say to me, oh, so, you tell companies if they have a breach or not. No. What we do as an outside investigator is we help gather all of the information with the internal folks at our client. We also, in cases where clients have very, very sophisticated internal IT security staff and investigation staff, which we do for a major university, we will act as their independent third party to validate their findings, review their root cause analysis, their business impact analysis, and provide an opinion, an expert opinion on what they have found themselves. All of that information is turned over to legal counsel, and it is very, very important that legal counsel make the decision on when we are going to call something a breach, a reportable breach, or simply an incident. And so that's where Renee comes in, and that's where she and her client and their boards of directors and everyone else will start to do their arm wrestling and figure everything out and start to move into the next crucial phase. So Renee, if you would be so kind to pick up and talk about all the fun you have.
I think it's important just to reiterate and go through what the breach analysis is for an entity, whether you be a business associate who has the obligation to report a breach to a covered entity, or whether you're the covered entity that is performing its own independent breach. One of the reasons why it's important for a business associate to be able to do an analysis, and this does not mean delaying the report to the covered entity because you're engaged in the analysis, but this really helps tee it up then for the covered entity and helps them to, really look at the roadmap that's been established by the business associate, so that, as is probably included in your business associate agreement, you can cooperate with the covered entity in providing the needed information both to individuals who are affected by the breach and then ultimately to the Office of Civil Rights. So a breach is defined as the acquisition, access, use, or disclosure of PHI in a manner that's not permitted under the privacy rule, and then which compromises the security or the privacy of the PHI. Next slide, please. So in order to understand or to help identify what a breach is, you should, next slide, please. You should really answer 4 questions. One is, what's the nature and extent of the PHI that's actually involved? And that looks at the types of identifiers that are disclosed inappropriately, and then the likelihood of the re-identification of that information. So let's give an example of a client that I had who had a business associate who was a third-party administrator and did their billing for them. And this biller inadvertently sent the explanation of benefits, which pretty much includes your name, your address, your telephone number, your healthcare provider, what diagnosis you had, and what the charges for those services were. And those EOBs were sent to all of the wrong individuals. So in that instance, to me, the first question has been answered in the affirmative. So you don't have to you weigh all 4 of these questions. But again, if you're looking at credit card and financial information, social security numbers, the idea is, remember, if you IIHI, or individually identifiable health information, are components of PHI. So you have to look at how many of those data points or data pieces have been released, and then figure out how many of them can be put together to re-identify the individual. One thing that I will say, and I do handle quite a number of clients that deal with, that are mental health treatment and substance abuse providers, and quite frankly, with that diagnosis, I don't really need to go much further in my analysis, because to me, that's a nuclear mishap that really does tip the scale, in my mind, to having that be a breach because of the information that's actually disclosed. That being said, you also have to look at who was the authorized person who used the PHI, or to whom the PHI was disclosed. So let's say those EOBs that were mistakenly sent to the wrong patients, let's say those EOBs were disclosed to another business associate, or to another, or were sent back to the covered entity. Well, when you have two entities, a covered entity and a business associate, that are both subject to the same rules regarding the privacy of that information, that again is a factor to consider, and it might mitigate whether or not you believe that you've had an actual breach, because you can check with that individual if that entity, if they've received that information, and if they're subject to the same privacy requirements, then I think that that goes to really mitigating that there's been a breach. On the other hand, if you have de-identified pieces of information and, you know, it got disclosed to someone who is a sophisticated entity and could possibly put that information back together to identify the individual, that factor might make me feel we're leaning more towards a breach. The third question is, was the PHI actually viewed or accessed? And we've used Angie's company in the past in a specific instance where a physician lost his laptop, and the laptop, obviously, because he was a physician and he had an electronic medical record system, contained all of his patients' PHI. So she was able to demonstrate by getting the laptop. Luckily, the laptop was refound, and in most cases they're lost forever, and the police aren't particularly interested in getting it back. So then you have to fall back on, well, was it viewed or not? And you know, I think exercise caution and presume it might have been. But anyway, she was able to come in and look at the computer and look at the audit trail and demonstrate for us that there was no access really, and the PHI was not actually viewed. So that again right away told us that we can't possibly have a breach. The fourth question is the extent to which the risk of the PHI being seen by someone else has been mitigated. I had a case recently with a mental health treatment provider, and as I said, I usually look at that as a nuclear event. But we had mental health treatment. We had a notice being sent to patients of a particular physician that the physician was no longer going to be at the facility. He was moving on, and we wanted to notify the individual patients that that physician was moving to a different practice. And who else that patient could utilize either at the client's staff, or if they were referring them to another provider who could provide the same services. So we were actually looking at, and this will be important when we get to the next couple of slides, we were initially looking at over 600 letters that were sent to the right address but had the wrong patient's name on them. So therefore, all those individuals found out who else were clients of that mental health treatment provider, and actually who was seeing them, which was a doctor who had departed. So we started out with 642 letters, which was a real shocker. And we said, okay, let's try to mitigate the best we can. We're going to send a letter out to the clients, letting them know what happened and asking them if they haven't opened the letter, could they please return it back to the provider? And we sent pre-stamped envelopes that they could enclose the letters in and send unopened letters back to us. And these clients were really, really helpful. And from that, we got the number down to about 500. So then we're right on the edge. We don't know whether we're going to need to notify the Office of Civil Rights immediately or whether or not we can maybe get some more letters back. So we were patient. We still had 60 days to notify. We were also looking at what had caused the breach and doing our own kind of root cause analysis. We knew this was not a security issue in the sense that, it involved a computerized or a security risk so much. It was really human error in compiling an Excel sheet. So the Postal Service was very helpful because, they returned the letters as being unable to be delivered because of the wrong addressee. So by the time all was said and done, we had our number down to 300. So there we had an example of we mitigated, and by mitigating, we reduced the number down to less than or around 500. So we expended the effort. And we also then, there are other instances, let's say, where you fax something to the wrong provider, or you send it to Joe's Pizza, and you've done that because you faxed it to them, and you get their representation that they have destroyed it. So therefore, in that instance, if it's not a mental health treatment provider and you don't think there was a lot of identifiable PHI, and then that the PHI has been destroyed or returned to you, then, those factors mitigate accepting or believing that you have a breach. Next slide, please. Okay. So how do you know who to identify? This is where you come in, and one of the important things to look at is, and make sure you're accurate with, and I think Angie can help us with this, is, if you have the ability or if you have a security breach and you have a consultant as Angie with you, be absolutely certain who is being affected or who has been affected by the breach, because the last thing you want to do is to be telling people that you've had a breach of that information and it really wasn't their information, because this really creates undue and unnecessary anxiety on the part of the people being notified. And it also goes to enhance your damage to your reputation by having that many individuals being affected. And that's another reason, Angie, don't you think, why it's important to have legal counsel who know what it is they're doing to make sure you don't open up this whole can of worms of notifying individuals that don't need to be notified?
Oh my gosh, yes, that is such an excellent point. And oftentimes we're party to the conversations where legal counsel, along with CEOs and boards of directors and compliance folks, are trying to make the decision of how many people to notify and are we absolutely certain, and those types of things. And too often I have heard folks say, well, let's just err on the side of caution and notify everybody. And that is very problematic, as Renee just explained. And then the other reason why legal counsel is so important when we're dealing with regulators is I have also seen that approach taken as it relates to notifying the Office of Civil Rights. And that overabundance of caution where misinformed or unknowledgeable folks say, well, let's just notify them and be really cautious just in case. That can really trigger an investigation that comes in, and it has in some major breaches it has triggered investigations that came in and found a whole host of other problems. Because when the investigation happens of a breach of more than 500 people, it doesn't just look at that one thing. It will look at every system. They will look at every conceivable problem that you have in your infrastructure and in your organization. So that is absolutely crucial to notify the affected people and the regulators properly and in the most limited way possible.
Yes, so then I think you're certainly embellishing and fleshing out what I said. Determining what information needs to go in the notification and determining who will do the notification, and is it an ongoing process. The OCR has made it quite clear in the regulations what information needs to go into the letter to individuals. Determining who will do the notification, it's the covered entity's legal duty to accomplish that. And is it going to be an ongoing process? It may very well be. The OCR has made it clear that although you have 60 days to notify individuals of the breach, they really want you to, if you have a confirmed breach, you know who the individuals are involved, you have enough information to let people know, you let them know as much information as you have, and then you tell them you will supplement it as needed. One thing the OCR is, they don't want you to drag your feet, and they don't want you to say, oh, I didn't know enough information, so I was hesitant to send the letter. And I can tell you of one case where it was a pharmacy who had a major breach of their information, and the OCR found out it because it was reported in the local newspaper. So that's the last thing you want. The pharmacy had enough information to notify individuals, but the OCR found out about it by looking at the local newspaper. So that's not the way you want things to unfold for the OCR. Next slide, please. So what are the requirements? Well, first of all, send the notification by first class mail to the last known address. You can send it via email if the individual specifies that as a preference. I think that's difficult to find out many times, but that's what the OCR may require. If there's a real imminent belief that if there's belief that the PHI is going to be imminently used for improper purposes, let's say it's their social security number or credit card number or something like that, then the OCR wants you to give telephone notification. And the other thing that's interesting is if you are unsure of the address for at least 10 people who are affected by the breach, 10 or more, the OCR wants you to put that information on your website and to leave it up there for at least 90 days in the thought that those people will be able to see the breach notification. Next slide, please. Oh, and also includes a toll-free number where they can talk to someone and find out what the issue is. So remember when I was talking about the mental health provider that sent letters out to 642 people, and why we were just, praying and hoping and keeping our fingers crossed that we got it down below 500, is because if it's greater than 500 people, you have to publish the breach in a prominent media outlet, and the media outlet has to be within a state or a jurisdiction where most of the people that have been affected by the breach. Okay, so if it happens in Dauphin County, and that's where most of the people reside who have been affected, that's where the media outlet needs to be. You have to notify the HHS or the OCR immediately if it's over 500 people, and because obviously they're going to know about a breach of that size. And remember, we just talked about how the OCR found out via a newspaper story. The Health and Human Services or the OCR will post or list those organizations that have breaches of more than 500 people on its own on their website. And I can pretty much guarantee that if you have a breach of that magnitude, as Angie spoke about, you're going to have the OCR knocking on your door. And that's one of the reasons why it's so important to have legal counsel who knows what they're doing at the get-go, because you have to document what you've done to mitigate, what was your root cause analysis. You have to document your breach analysis and everything else that leads up to the notification, and the notification with the mindset that you can be sure the OCR is going to be coming in and checking on you and seeing what you did. So you have to think about that as you're moving forward. The only time you're allowed to delay the notification to more than 500 people, or even if it's less than 500 people, is if you have notification from another agency not to do it because there's other agencies involved that are looking at the breach. I've had one instance where the client was a billing agency, and they were told by the IRS not to notify anybody about the breach because they were doing their own investigation about rogue employees that were used by the billing agency to use client individual information to file false returns under the IRS. So if it's less than 500 people, you have the option of putting it on the OCR's log, although it's a pain in the neck because you put each person's name individually. There's no way to group all those individuals on the OCR's website. Keep in mind, the business associate, as we said, has 60 days, 60 calendar days to notify the covered entity. And when they notify the covered entity, they have to include each affected individual and any other information that the covered entity might need to notify affected individuals. And most covered entities that are worth their salt or have some legal counsel helping them, that's going to be included in the business associate agreement. So it will be a contractual obligation as well as a regulatory obligation. Next slide, please. One thing to note, to recognize, and I think I've already touched on this a little bit, it used to be the OCR would only investigate individual complaints, and that was a really nice soft process, and I think I talked about that before. Now the OCR with the HITECH Act, and this is something that Angie alluded to and talked about, is once the complaint is filed, they're going to do an investigation, but if they start finding stuff that smells bad or looks like you have not been a good corporate HIPAA citizen, they're going to open up the investigation and take it wherever they think it's appropriate to go. One of the things, if you look at most of the agreements that are entered into with the OCR, in addition to the fines that are imposed on individuals, is many, many, many covered entities, and now you're going to be seeing business associates because they are covered under the security rule, is what was your initial risk analysis, and did you actually do a well-developed risk analysis? And was there any failure to encrypt? I'm just going to ask Angie to talk about this for a minute, because encryption is not expensive these days, but I have clients that still feel that if they encrypt, their patients might not be able to view the emails or the text. And Angie, aren't there other ways to secure the information besides going to encryption that will satisfy this security analysis requirement?
Yes, there absolutely are. And unfortunately, I see so much information, misinformation out there about encryption. Encryption is not a requirement. It is required that you address it. And so in every piece of your infrastructure, in every method that you store, transmit, or process patient health information, you need to perform a risk assessment and identify ways that you protect that information. It is true that encryption is your get-out-of-jail-free card. It is one of the quickest and easiest ways to protect information when we're talking about mobile devices, we're talking about laptops and that type of thing. Where I see the most misinformation, and let me say that not having enough money is is one of the absolute poorest things that you can say. It is not a valid defense in any possible way. Where I see the most misinformation is around data at rest. And so I see a lot of clients struggling. We don't know what we're going to do with our servers. We don't know what we're going to do with our desktops. And my first question is, well, how are you addressing the risk? And most of the time I get dead silence or, what do you mean? And for instance, servers that are in a locked data center, in locked cabinets, that is addressed. You've addressed the security of those devices from an encryption standpoint, as well as addressing the issue where if you have legacy systems or you have systems that do not support encryption, you may address the security of those without encryption by talking about these other controls that you've put in place to protect the information. So it's super crucial that you evaluate every asset class and every type of information, because you may not always need encryption on everything. You may already be doing other things that are perfectly acceptable and meet the requirement that you address the risk.
Thanks, Angie. I'll just mention real quickly that, your vendor oversight process is very important. Excuse me for being a little crass, but, you have to watch who you get into bed with, and you really have to do your due diligence on your vendors. And we talked about that in the second webinar, but I think it's also important to remember and keep that in the forefront. Next slide, please. The ramifications to a data breach are, first of all, your professional reputation, and one of the things you need to be aware of, and we'll talk about this with the next steps, is if you don't have the financial resources to use an external PR team, you should at least use your HR or maybe your marketing folks in-house to be able to respond to the breach and how to handle media inquiries. Have a single spokesperson, and sometimes the answer is it's still under investigation. This is what we know so far. The second thing that you need to establish is a customer hotline, and you need all those folks who are handling that hotline to be scripted and to be giving out the same information to everyone who calls, because there's nothing worse than having multiple facts out there describing a situation like this when people are already very, very upset and angry, etc. You should and could, I think, is a good reputation and customer service aspect. Include information on the steps you've taken, what steps consumers should take, and that's one of the things that the OCR says you could include in the letter to your patients. Now, it's not necessary for everyone. It's really when it involves information that could be have financial implications for the individuals whose data has been breached. But, usually you would put in there then something about Experian or one of the other credit companies that you will provide a year's free check to the individual so they can make sure that their credit isn't being harmed. The other legal ramifications are government fines and enforcement costs. There are also lawsuit costs. No one has a private right of action to sue directly under HIPAA, but I can tell you what, plaintiff counsel are getting very savvy in either filing class action suits, if it's a large breach, against the covered entity, or suing under state law in privacy actions or negligence claims and even professional licensure actions. There's an interesting case, and I'll just cover it briefly. Walgreens was asked to pay $1.44 million in a lawsuit brought against it because a pharmacist that worked at Walgreens was divorced, but she had heard that her husband had acquired a sexually transmitted disease, and she was interested in whether or not she could also have acquired it. So the second wife was someone who had their prescriptions obtained from Walgreens, and the first wife checked her medical records as they were available at Walgreens. So not only was the Walgreens sued for negligence for allowing not having computer system and policies and procedures not being in place and enforced, but the pharmacist also faced professional liability under her professional state licensure law because she violated the privacy of the second wife. So I'd like to go to the last slide if we could, because I know that we're probably running short of time. I guess that's slide 16. You have to prepare for a breach, as Angie said, to the same extent that you would, I guess, have to be prepared for disaster relief. You need to think about what will be your steps, what are your policies and procedures specifically for handling a breach. You know, you should have a breach team identified and who you're going to call, sort of thing, because invariably this stuff will happen on a weekend, and you need to know what executive staff and what other staff or forensic administrative staff needs to be brought on board quickly and be able to hit the ground running. Secondly, do you have breach insurance, and do you understand what is contained in insurance? Do you have a PR team in place? Do you know of someone that you can access immediately? And when I talked about the mental health client that I had that had the breach, and this is not to toot my own horn, but that was one of the things that I had implemented in their policies and procedures, and I guess they must have listened to me because they handled that breach with excellence. By the time they called me, like the third day, they had pretty much found out what was needed. They already had their call center. They already had their PR firm in place, and they were doing a fabulous job. So that just, goes to the point of preparation ends up to be the best way to deal with this and the best way to manage and go through this whole breach process. Don't delay in implementing these activities and these actions because, you could definitely be caught off guard. There's no immunity to a breach. And, it's a likely scenario for most covered entities and for business associates moving forward. So I think that concludes my portion of the presentation. And I don't know if, Angie, if we have questions, if you want to open it up to that.
Absolutely. We're going to open up for some questions from the audience. And Angie, Renee, excellent job. This has been fantastic information. If you have to drop off, I do want to note, since we are at 1 o'clock or a little bit over, that we will be following up. As I said at the beginning, we're going to be sharing the recording and following up with all of the participants. Additionally, we had just a little bit of a technicality on one of the slides, so we'll be sharing as follow-up the 4 questions to a breach analysis that Renee did cover during her section. So that will come out to you as well. So at this point, I'm going to go ahead and open up to some audience questions. And Angie or Renee, let's start with, when does a security event become an incident?
I'm going to punt that to you, Angie.
I'm happy to answer that. A security event becomes an incident whenever we are talking about interconnected systems where there is a pathway to the electronically stored patient health information. So that's still a very vague answer, but the security event definition really today, the event kind of starts off generally as some type of an anomaly. And it may be something such as simple as a person can't print. It may be something as complicated as all of a sudden your help desk is completely overrun because no one can access anything. So any of those events can trigger. What's most important is that you have an incident response plan. I am a huge fan of graphical incident response plans. Obviously, you need the written document, but the graphical plan where everyone knows who's who in the zoo and whose responsibility each task will fall to, that's very crucial, because that plan will help your team understand when an event needs to be escalated to an incident and when the incident needs to be escalated to a potential breach.
So I think kind of going with that, are there certain security incidents that are harder to investigate than others?
Well, I can tell you that my heart really goes out to any IT security folks in healthcare, because I can tell you that healthcare events, incidents, and breaches are exponentially harder to deal with than financial and personally identifiable information. There are very, very robust tools from a forensic and investigation perspective that help us in a very automated, fast way. Still not as fast as what we see on CSI on television, but in a very fast way, we can automate the searching for valid credit card numbers, valid social security numbers, and we can glean that information very fast, very effectively, even when it's in JPEGs and pictures and scanned documents. The problem with healthcare information when it is a breach of information outside of a structured database is it is incredibly difficult to write search criteria and search code into the forensic tools to automate the finding of that. So we've literally had incidents that we've investigated where I literally had to have the forensic engineer open every single email of a 10,000 page email database to look for information in order to be able to determine who was affected, and then to make a determination on whether or not there was information in there that may constitute a breach. So I would say that healthcare as an industry is harder. Then in terms of types of incidents, I will say that live network attacks are some of the most difficult, because as things are going on, evidence is literally being destroyed as everything continues to happen. And there are certain types of attacks, incidents, where the only evidence literally exists in live memory of live systems. And that adds a complexity to the investigation around very specialized tools, very specialized expertise.
Okay, I'm going to take a couple more questions because it looks like everybody's staying with us. And this kind of leads to the next one. When should a forensic company then be called? And when can an organization decide to just do the investigation internally?
Well, I think one of the great things about a good forensic company who is truly your partner is that they will guide you with just telephone support and help you make that decision. I have worked with clients where they've worked with folks, forensic folks, who treated them like they were stupid, or, kind of came in with this, we know everything, our team will take it from here kind of attitude. And I don't believe in that. I think that many organizations have excellent staff that can do many of the basics themselves. The real key for an organization to know what their limitations are is to do annual incident response training. And in that incident response training, each year, different types of attacks and threats will be discussed. Scenarios will be done in a tabletop exercise format. And that will help the organization understand their own limitations and their own capability. And we rely and approach our investigation as a very collaborative way to work. So for instance, we had an investigation that involved electronic health records, but it also involved HR systems that contained payroll. And so there were aspects of the investigation where internally they were perfectly suited to do their own analysis around a particular type of data set, but in another they weren't. And so we were very collaborative in our work together. So it really just depends on every organization understanding its capabilities. The most important thing to understand is if you are going, at some point you probably are going to need a forensic investigator to help you. Having them already vetted and under contract is crucial, because I have had folks call us on, to say we need help, the attack is going on right now. However, the person who was calling us asking us for help didn't have budgetary authority to engage us. And I can tell you that these types of things rarely happen between 8 to 5, Monday through Friday. They happen nights, they happen weekends, they happen holidays, and they definitely happen when, people are on vacation. So that's one of the most crucial things about the outsourced aspect is who has the authority to call in the strategic forensic partner and who has the budgetary permission to authorize them to be deployed.
Yeah, and having that relationship just seems to make sense.
Mm-hmm.
So one more question, and I think I can direct this one to Renee.
Right.
Renee, what happens if I don't do a breach analysis?
If you don't do a breach analysis, it automatically takes a deferral position that it's a breach. So if the RCR comes in and does any kind of audit and they see that you have something that looks like a breach and you did not do the analysis and you did not report it, then that's a violation of HIPAA. It's much better to do the legwork and be sure. Or else, if you want to not do it, but just be aware that there's the repercussions of failing to do the breach analysis.
Yeah, and one of the things I'd like to add, Renee, I don't know if you see this with your client, but, these are a lot of big words. And when you use this term breach analysis, we're not talking about 50-page reports. Let's say in the case of having malware on a desktop computer. Well, your breach analysis can consist of the fact that you check the configuration and your group policy settings where your desktop computers were not permitted to store any information on the hard drive, and you've looked at the profile of the virus and what its behavior characteristics are, and you've analyzed it in a test bed, then your breach analysis is there was no breach because there was no data stored on the device, and that the configurations were validated, and here's the profile of the virus. That fits on one page and can be a bunch of bullet points, truly. So it does, there doesn't have to be this complexity and this enormity. It really can be quite simple. And I think the enormity and the complexity sometimes tends to be what scares folks, and they don't follow through with all of these very important things that they need to do.
I agree. And the other thing to do is I didn't mention it, one of the other requirements is to keep a log of all the breaches that you've confirmed. But I think you're right. It doesn't always require an inordinate amount of manpower. Some things, like I said, if, like you're saying, some of them are no-brainers, and you just go ahead and remediate and mitigate the harm.
Yeah, and when we talk about a log, in a lot of organizations, your log may simply be your help desk ticketing system as people are working back and forth through tasks. And things are deemed to not escalate past an incident or an event.
I concur.
Excellent.
Any other?
Oh, go ahead, Renee.
No. Are there any other questions for us, Angie?
I don't see any coming across, so we'll go ahead and wrap up there. We're at about a quarter after the hour. As always, Angie and Renee, we really appreciate your time. Obviously, it's information our listeners want to hear because everybody's stayed on with us. If we weren't able to get to your question, I promise we will follow up with you. As I noted, you'll be getting the recording and the breach analysis questions in follow-up. If you would take a moment to complete the survey, again, you can request additional information in there as well. Renee, Angie, any last thoughts?
No, I just thank everybody for attending, and I certainly hope that this information and the last other two webinars have been helpful also.
My parting thought would be that compliance and risk management are a journey, and that the sooner that you start to look at your risk management program, that's really the key to being able to deal with these incidents in a way where people's hair literally isn't on fire. And so if I could leave folks with one thought, it is that if you haven't done your risk assessment, you need to get it done. If you've done your risk assessment and you're letting the remediation slide, now is the time to dust that off and get a move on. So I hope you've enjoyed the three-part series. I truly have enjoyed working with Renee. I've learned a ton from her, and I thank you so much for being a part of this three-part series.
Excellent.
My
Thanks
pleasure.
so much. Wonderful afternoon. Thanks. Bye-bye.
Bye-bye.
Hi, everyone.